A pleasant day and a warm welcome to Law and Order. We're discussing many areas regarding law to give you certain advices, and from our previous episode we were discussing about land law, and today also we are going to focus on the same topic but in a different scope with regard to ownership and certain other aspects that is very important and mandatory when it comes to a particular precise knowledge on land. So today also we invited Mr. Sapumal Bandara, attorney at law. Thank you very much, sir, for attending the discussion. And it's really a pleasure to have you on board in the discussion. So sir, we were discussing about land law, 2 programs, and we had a thorough idea about the certain other requirements and many areas that we were discussing regarding the land. There is a land, I own the land. Sometimes there might be certain cases, certain person, suppose my brother, one of my friends, we both own the same land, something like co-ownership. Can you just explain it?
Yes, co-ownership is also a important legal concept where a co-ownership can be created in many ways. Now, for an example, that you and I can purchase a property, paying the seller in equal proportions or by paying the seller, and so you and I can become the joint owners of the property because we purchase it from a common seller and we have not demarcated what portion belongs to you and what portion belongs to me.
Right.
And also that say that you and I are siblings, and after with the death of our parents we inherit the property, so in proportions in terms of law. So you and I have become co-owners. Say that our father, you and I are siblings, and our father purchases a property in your name and in my name as well. So we in these scenarios a co-ownership is created, where co-ownership is that you and I both are equally entitled to certain portions of the share, but the portion has not been demarcated.
Right.
Portion had not been identified. We both have a claim to the entire land, to a particular undivided portion. You have undivided half share, I have undivided half share, but your undivided half share is not defined, my undivided half share is not defined.
That means we both have the ownership but not defined.
Not defined, not divided.
Right. So there's a mango tree in the land. So it belongs to you, it belongs to me as well.
Yes.
I'm plucking the fruits entirely without giving anything to you.
Yes.
So we both are owners, but the entire harvest of that particular plantation or whatever it is grabbed by myself. So I am not adhering to that particular co-ownership rights without letting your portion allocated to your side legally. So is that a dispute?
Definitely, it creates a dispute. I think it's a very common occurrence where people who enjoy co-owned properties, they do not share the harvest or the producers of the property. So that creates problems among the co-owners. So if you enjoy the fruits of the mango tree alone, then you are violating my rights as a co-owner.
Right.
So as you said, if you are entitled only to a half share of the produce or the produce of the mango tree. So I am entitled to the balance half share. So the dispute arises when you refuse us to recognize my right to the other half share. So that is how most of these co-owned properties are brought before court.
Right. So there's one more thing that I wanted to emphasize. I think that will be a good question as well from the side of the audience. When it comes to a particular access, a road or a route, each and every land has the right to access. In that co-ownership case, if the particular half share is being equally divided without any dispute, as in the land, what about the access? That means if there is only one road can they keep that particular road in common?
Yes. Now, before answering that question, Charita, let me put it in this way.
Right.
That is, now a co-owned land can be partitioned or divided among the co-owners in two ways. One is upon mutual agreement.
Right.
So, upon mutual agreement, the co-owners can decide to partition the land among themselves. So, for that they prepare a survey plan and they partition the land to number of lots equivalent to the number of co-owners, and then upon their mutual agreement they execute a amicable deed of partition claiming or confirming their title to each and every lot. Now, for example, now say that 4 persons are co-owners to a particular land. Right. So, all these 4 co-owners are in agreement to divide this among themselves amicably. Right. So, they prepare a survey plan depicting 4 lots, and you agree to take lot number 1, I agree to take lot number 2, other 2 agree to take lot number 3 and 4 respectively.
Right.
So, there is no dispute. There is no problem. We all are in agreement. We prepared a survey plan and then we have decided to take our portions based on the survey plan, and then we proceed to execute a amicable partition plan. Right. So, in that partition plan, you will get lot number 1, I will get lot number 2, the other 2 will get lot number 3 and 4 respectively. So, there is no question. That is called amicable partition. So, in order to be an amicable partition, if it is to be an amicable partition, then all these other aspects also should be taken into consideration, just like the access ways. So, now suppose that if once the land is partitioned, if I am not being given an access way, then it cannot be treated as a fair partitioning. So, I might not agree with you.
Yes.
Now you prepare a survey plan without providing me a reasonable access to the portion that I am claiming.
Right.
So, there's a disagreement.
Yes.
So, I will not agree. So, I will not incline to amicably sort it out with you, because I have not been given an adequate roadway. So, when it comes to amicable partitions, it is always a precedent of agreement in respect of all aspects, not only the extent of land, but also the buildings standing thereon, other plantation standing thereon, right of way, and all the other benefits and everything.
Right.
On the land.
On the land, they should be divided ethically, and there should not be any disputes among the owners. Right. In that case, if there is any particular dispute, obviously we have to go before court and solve that particular thing. And if I am a purchaser, and if I am going to purchase a co-owned property, like somewhere around 2 or 3 owners are there, particularly to the property, if all those 3 have given their consent, I can purchase it without any trouble.
Yes.
In that case, if any particular confusion or any disagreement occurs between those co-owners, without knowing one person, the other 2 people trying to sell that property to me, and by way of notarial execution or by putting a fake signature or something like that, I buys the particular land, purchases that land. What is the legal principle applies there?
Now, Charita, it's a very important aspect where now you must take all precautions before you purchase a property, especially a land. You must take all precautions to avoid any future issue.
Right.
To avoid any future issue. Now, you must do a thorough search in the land registry to see whether there had been any deeds executed, any notarially executed documents registered, or sometimes caveats, priority notice, seizure notice, to see whether there are any encumbrance, whether there is any encumbrance or whether there are any encumbrances to the property. So you must be very careful. So if you purchase a property knowing that it's a co-owned property, and if you purchase an undivided share, then that is your choice, and you are at a risk of either, if these parties are not mutually agree to divide it among themselves, you are at a risk that you might go before courts to get your portions partitioned from the other portions. So when you are purchasing a co-owned property, if all the co-owners are not coming on board, all the co-owners are not selling the land to you, then you are at a slight risk of going to courts. So that's number one. And your second scenario is that where now I purchase a property from 4 co-owners, where some a particular person signs a document, and he impersonates and he signs the document as if one of the co-owners, but later it transpires that the signature is false, and that the actual co-owner has not a part of this deed. So then what happens? Then I, as the purchaser, should have been vigilant. So there is a legal principle called caveat emptor. Buyer be aware, buyer must be vigilant.
Right.
So the person whose signature has been falsely put on the deed is a completely an innocent victim. So his rights have been safeguarded. So how about my rights then?
Yes.
I'm also innocent victim, no?
Yes.
In one hand. So now let's say that 4 co-owners have transferred the property to me, and I verily believe that you also, Charita also has signed this deed. I don't know you personally.
Yes.
So I believe the person who appears before me on the date of the signing of the deed is Charita. So I have no hesitation. I purchase it, and later it transpires that you were not involved in this execution of deed. On that day, you were having some TV program, and you were not even in the area, right? So you are a victim. So you can always say that no, I have not executed this deed, so my undivided share has not been properly transferred. So upon proof of that, you can take your portion out of that. Now what is the remedy available to me? Now I am also in one hand innocent victim. I didn't know. All your brothers have come to me, and they have indicated you and some person has impersonated, and I purchased this with the pure idea that you are the actual person. So then what is the remedy available to me? Then I can claim damages from the other persons who have sold the land to me. So I can claim now I have paid in full.
Yes.
I have paid in full. So I can claim that 1/4 share or whatever the undivided share belong to you, the money is the proportionate amount from them. And also in addition to that, I can claim damages because I did not intend to purchase an undivided property.
Yes.
I intend to purchase a full property where they have misled me, they have misdirected me, and they misrepresented the fact that you also have signed. So I am also an innocent victim. So I can claim damages from them. Right. And we both are safeguarded before law.
Right. In that case, we both are safeguarded, but you mentioned that there's a principle, the buyer be aware.
Yes.
In that case, the other 3 people who just impersonate some other person and just executed the deed for you, can they say that now buyer must be aware and he was not aware, and we are not going to pay that portion, that means my portion's amount to you back, and instead they will give my portion back to me, and the rest of the 3/4 you're going to hand it over. In that case, what is the applicability of that buyer be aware?
Yes. Now it all depends on circumstances. Now let's say now your brothers approached me. One brother is very well known to me, and they represent that all 4 brothers are willing to transfer this property to me. So I have no doubt about the genuineness of you all. And before executing the document, my notary has checked your identity card, your national identity card. And nowadays it's difficult. Now from last year onwards, last year there were serious amendments brought to the Prevention of Frauds Ordinance, Notaries Ordinance, and as well as Registration of Documents Ordinance. Now in the present context, with the operation of these new laws, it is very difficult to execute a fraudulent deed. Because you know why? One of the requirements is that the notary must affix photographs of the parties. So the notary must affix photographs of the parties who had signed. So if your photograph is affixed in the deed, that is a prima facie evidence to say that you were present at the execution and notary has affixed your photograph. And in addition to that, your brother can bring your photograph. No? In addition to that, all parties must place their thumb impression on the deed itself. So now with the introduction of these new laws, it is very difficult to fabricate a deed or to make a fraudulent deed. But there may be instances, you cannot prevent every scenario and you cannot cater all probable scenarios when you are introducing a law, but still there is a serious halt or serious problem with regard to this execution of false deeds. But so what I say is all that are depending on circumstances. So and there's another principle where the court does not expect one to perform impossible. That is, now if it is impossible for, now I cannot, how can I know that you are not a brother for him if I do not, if you produce me a national identity card, your birth certificate, and I look at your documents, I do not go for a DNA test obviously to see whether you are related to them or not. So court does not go to that extent also. So upon that you can decide whether you are reasonably vigilant on that. Like if you are not reasonably vigilant on that, now let's say now you are not there when the document was signed. At the time of the document or the deed was signed, you were absent, you are not present before the notary. So anyway, I opted to purchase it, and your other brothers say we will obtain his signature later on, don't worry, you execute it and give us the money, we will sort it out. So that is my negligence. So I was not reasonably vigilant. So in those instances, I cannot say that okay, I did know. So it is because of my negligence. So other than that, I can always say that okay, I reasonably exercised my diligence and I could not apprehend that you have been impersonated.
That means all depends on circumstances. Depending on different circumstances, the law applicability and how that scenario modulates differs. And when it comes to that particular co-owned properties, like if a person is going to purchase, we have to check and we have to make sure all the particular correct co-owners are there. And once it is been purchased, when the title or particular the documents, deeds notarially executed in a proper way, we have the legal title and those things without any issue. And when it comes to a particular scenario where the court intervenes in a particular decision, for example, now there's a co-owned property, I myself buying, there is a particular case pending. For example, like in that previous scenario that you were elaborating, 4 co-owned persons for a single property, one person has not been signed, another assigned person have signed that thing. Now I am eligible for the 3 portions out of the 4, and that one portion is in dispute. The court intervenes. That means the other 3 persons should pay me the remaining, that means the allocated amount for that particular person. Now the case is being pending. Now it's been urgent, prima facie, honestly, that I myself purchase the land to put up a building as soon as possible to start my own business. In that particular 3/4 of the land, can I initiate that thing while the case is pending?
Well, it is at your risk, because now if that also depends on the circumstances, where now let's say that the fourth owner, if he is asking to nullify the deed of partition altogether, then there is a problem.
Right.
Because now if he is not satisfied with the manner in which the other three have prepared this partition plan, then he would challenge the partition deed as well as the partition plan altogether. So in that event, if the court is satisfied, obviously if he can prove that he was not involved in preparation of this amicable partition plan, court would say this partition plan has been prepared without the consent of one party. Right. So it cannot be treated as a mutually agreed or amicable partition plan.
That means it also depends on circumstances.
So a deed executed based on a plan which had not been mutually agreed upon, then there is a problem, because the third person might come and say, no, you the other co-owners have done something not only illegal but also very unethical, and therefore he might ask for the total quashing or cancellation of the partition deed. So in that event, even if I am the purchaser, although the other three are not asking, other three are entitled to the property, that other co-owner who had been left out fraudulently in the process of making the partition plan and the partition deed can take a court order to cancel both partition plan and the partition deed. In that event, even though they have given me 3/4 of the land, although since they are not asking that property back and they are not returning me money on that 3/4 share, I am entitled for the 3/4 share. But still, since it is not properly partitioned, it is not properly demarcated, the other one can claim his 1/4 from anywhere of the land.
Right.
Anywhere of the land. So if I put up a building on a particular portion, he might say, no, you cannot put up the building there, because I am claiming my 1/4 from there. So it's at liberty. So it's its choice. So it's a huge risk.
Huge risk, and at our own risk, if we are putting up a building, we should do. And in the sense, like, if I may ask finally this question, in that particular scenario, the fourth person claiming that particular partition portion, he can claim anywhere, no? Like, I myself honestly have purchased this land and I'm putting up the building honestly to put up my business. So like, who gets the priority? That means if my building is already put up, so that particular portion already belongs to me, and the particular partition being proceeded, letting that portion out, or that fourth person can claim anyway. Is there any priority, or it depends on the circumstances?
No, priority is always there. Now the person who was the original owner, original owner's rights, because I have purchased the rights of the original owners. So if one of the original owners claims that his rights have been infringed and his rights have been fraudulently transferred, then he must be given priority. Because what I get from them.
Right. Okay. So an insightful discussion. So, sir, like we discussed many of those areas, and thank you very much for joining us with this discussion. So today we were discussing about certain issues pertaining to lands, and in certain cases the ownership, how partition proceeds, and related scenarios, elaborating you to get the maximum benefit. So thank you very much, Mr. Sapumal Bandara, attorney at law.
Thank you very much
for joining the discussion. So from Law and Order, we have discussed many areas, and these set of programs are focusing on land law. So land, which is a very important vital aspect when it comes to each and everyone's dream, future, realistics, and everyone, so they need to purchase a land without any trouble. So we are focusing this program to you, dedicated to you, to bring forth that particular knowledge that you are intending. So thank you very much for watching. Stay tuned with the rest of the programs. Do stay tuned for more episodes from Law and Order, which will give certain knowledge in order to enhance the law and even to let you a successful life without falling in trouble. So thank you very much. Have a pleasant day.